Let's talk about no cash bail and the status of that statewide measure that was supposed to go into effect January 1st, but was ultimately blocked by the Illinois Supreme Court pending challenges from more than half of the state's attorneys in the state of Illinois. It's Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY, Springfield's News and Talk. We're live and local each and every weekday morning from 6 to 9, and you can always chime in live and local at 217-629-7970. That's the phone number. So just some background here. Of course, we've been tracking a whole host of different types of lawsuits in the state and federal courts concerning the state's gun ban, and now we kind of change our focus from the gun ban to another issue about crime and punishment, and that is whether or not individuals who are facing crimes and innocent until proven guilty, whether or not they languish in jail because they can't afford bail, as supporters of no cash bail say, or if they should be allowed to bail out for some kind of financial surety of sorts. So if you recall, this measure, the SAFE-T Act, it passed way back in January of 2021. I just want to make sure I get all the times right. I remember it was in the height of COVID. The Senate was in the Illinois Senate chambers at the state capitol. The House, they were actually at a convention center down the street in Springfield. I was following along from my truck as I watched remotely and was watching all of the debates. The Senate passed the SAFE-T Act, including the no cash bail provision, at like 3 or 4 in the morning with very little debate. There was very little debate in the Senate chamber. I think you had two sides with two speakers from each side allowed to sound off in the Illinois Senate. And this was in the early morning hours while everybody was sleeping, early January of 2021. So it passed out of there, and then on the final day of legislative session for the 101st General Assembly in early January of 2021, the measure, the SAFE-T Act, with the no cash bail provision, passed the House. Now, all of this, of course, without the law enforcement community being able to sound off and actually have a thorough understanding of what was being passed. There were rumblings in the background about, hey, they want to get rid of cash bail. What's that going to look like? But there wasn't really a true vetting, according to law enforcement officials across the state, who said that the SAFE-T Act is going to impact them negatively and it's going to hurt safety. So that was early January 2021. The governor signed it a few weeks later, and then, implementation of it, the no cash bail provision, was set way ahead of time into the future and wasn't set to take effect until January 1st of 2023, which was earlier this month. So you had from January of 2021 to January of 2023 for all of the debate to continue to happen about the SAFE-T Act. There was an election in between there, November of 2022. So while a lot of the provisions of the SAFE-T Act went into effect, everything from, certain regulations on police, setting up to make sure that all police in Illinois have body cameras. And there were multiple follow-up bills in the state legislature to clarify some of the issues within the SAFE-T Act. But one of the biggest issues was the no cash bail and who exactly would be underneath that no cash bail provision. Because the way the language was written, it essentially said that an individual had to be a threat to a specific individual in order for them to be held behind bars pending trial. But you have people pushing back saying that's way too specific, and this person who faces charges could actually be a general threat to the general public, so we should keep them behind bars. And you recall it even got up to Joe Rogan, where he was reading through the list of various charges that people could get out without bail, and that was like arson, intimidating a public official, second-degree murder, providing drugs for overdoses. I mean, he just went through a whole litany, and that was as we headed into the election. And even before the election, you had Democrats like Governor J.B. Pritzker say, yeah, we should probably make sure that it's clear that only violent offenders are allowed to be kept behind bars and not somebody who's charged for stealing a can of evaporated milk or something like that, right? So it became really politically heated into the 2022 election. The 22 election happens, and Democrats maintain dominance of the state house in both chambers and all statewide constitutional offices. And then they came back for fall veto session. They passed a 300-page bill that said, hey, we're modifying the no cash bail provision. Now people can be held pending trial if they fit this category of severe crimes, and a whole host of other things, including changing the questions that people had about trespass and whether or not a police officer could issue or arrest somebody that's trespassing on private property. They modified that to say they can't arrest them right away. They have to issue a summons or a citation first. And then only after that citation's issued, if the person doesn't leave the premises, then the law enforcement officer can arrest them. So they did modify that as well. But regardless of the 4 different amendments that were approved by the General Assembly and enacted by the governor, you still had states' attorneys across the state sue and sheriffs across the state sue. Altogether, 64 of them sued, and multiple different lawsuits all across the state. They consolidated those lawsuits into Kankakee County. The Kankakee County judge heard the challenge before the new year, and on just a few days before the new year, that Kankakee County judge issued a temporary restraining order against the state from enforcing no cash bail based on a variety of issues. Now, while the judge said the state did not violate the 3 readings rule, or the need for public debate, or the need for single subject, because they say that the challenge is that it was so broad. It dealt with crime, it dealt with jail, it dealt with police. The judge didn't say that that's the violation. The judge instead pointed to being a violation of separation of powers, and also violating the state constitution when it comes to the Victims' Rights Amendment and other provisions. So now we've got this case that before the new year, before it was set to go into effect, a Kankakee County judge said it's not going to go into effect for these counties while we work this out. But then it was appealed to the state Supreme Court, and on New Year's Eve, the state Supreme Court said we can't have a patchwork of counties implementing no cash bail and other counties not implementing cash bail or no cash bail. So the Supreme Court said we're going to suspend this law across the state so that there's even and equal administration of the justice system. And they'll take all these briefs and everything, and we'll probably get to some kind of resolution by March. Well, some of the first briefs filed, and one being the Illinois Attorney General's office filing that brief with the Illinois Supreme Court. We'll go through some of that and get some of your calls here with WMAY. It is Springfield's Morning News. I'm Greg Bishop, 217-629-7970. That's the phone number. And much more on this in the next segment with some of your calls as well. So we were going through some of the background of the Safety Act and the no cash bail provision that the Illinois Supreme Court suspended just before the new year, just before it was set to go into effect. And now we've got the first reply brief that was filed by the Illinois Attorney General's office, and you can follow along with all of these briefs. Just search the Illinois Supreme Court's website, and you'll be able to find this. High-profile Supreme Court cases. All right, and you can look at the filings and the appeals, and the latest case being that from the Attorney General's office. And you go through and you look at the case, and it talks about the issues presented and goes through and details all of the various facts that the Illinois Attorney General's office is trying to lay out here. And just to kind of pluck through some of this, it's almost 60 pages long. But it gives background about the case. 64 different counties suing, consolidated into Kankakee. The Kankakee County judge issuing a restraining order just before the new year that was only going to affect those 64 counties. The state Supreme Court said we can't have that kind of unequal justice across the state, so they suspended the entirety of no cash bail pending any outcome from the state Supreme Court. And then they said, here's the schedule of people who have to file. So the Attorney General filing saying that the issues presented are whether the Illinois Constitution prevents the General Assembly from eliminating monetary bail because monetary bail is required by either Article 1, Section 9, which makes criminal defendants bailable subject to certain expectations, or B, Article 1, Section 8.1, which guarantees certain rights to crime victims. So those are the two main elements that the Kankakee County judge said the no cash bail provision violates when it comes to the passage of this and implementing it. But then the Attorney General goes into the definition of bail, talking about, back in the day, it was a different type of consideration, saying that bail did not mean monetary bail, they say. The practice of allowing a defendant to be released pre-trial only upon payment. Rather, they say that the term bail referred to a pre-trial release more generally granted on conditions designed to ensure the defendant's appearance at future court appearances, making sure that they get their surety, they say. And the Illinois Constitution lays that out, saying that there needs to be some kind of surety. But it goes on to talk about, the definitions that were used in 1755 or in the 19th century. But what about the 1970 Constitution? Because that's the language that those pointing to the question of this violates the state constitution, having no cash bail. The Constitution sets out that it says, some kind of surety for bail. But the Attorney General's office says the legislative history of the 1970 Constitution also refutes plaintiffs' reading of that clause, which would protect the non-defendant's liberty, interested in instead of the institution's monetary bail. Indeed, the Attorney General's office says. The convention drafters expressly discussed the possibility that the General Assembly might at some point abolish monetary bail and agree that doing so would not violate the bail clause. So interesting to see that highlighted in their arguments, and they say, indeed, were the circuit court correct? The bail provision enacted in 1963 and applied without controversy for decades, since would be unconstitutional en masse, a result and cannot be squared with common sense, history, or, for that matter, Hemingway itself, a different type of ruling, which discusses at length the importance of the sections of Code of Criminal Procedure regarding and regulating pretrial release. So, again, cash bail, it's still something that's not being... No cash bail is not being enforced across the state because of actions taken by state's attorneys across the state, and the Kankakee County judge issuing a temporary restraining order, and the Illinois Supreme Court taking all of that now with briefs being filed. It's not going to be until March until that's dealt with. So we'll be keeping an eye on all of that as well here on WMAY. It is Springfield's Morning News. I'm Greg Bishop. Follow along with me on Twitter, Facebook, Instagram, YouTube. Really, you're going to get the most impact following me on Twitter or on YouTube, where we post regularly, including the live show 6 to 9 here on 92.7 WMA.